Okay. Good afternoon, ladies and gentlemen of the press. Today, before the Supreme Court, the lawyers for the petitioner brought a motion or an application to reopen his case on the grounds that were stated in the affidavit of the petitioner. And the basic ground was that at the time that the petitioner closed his case, the petitioner did so with a legitimate expectation that the petitioner would have the opportunity at the appropriate time to cross-examine the witnesses of the respondents. Now, ladies and gentlemen, you realize that the respondents filed witness statements. They also represented to the court that they were going to make themselves available for cross-examination. So at the point in time that the petitioner closed his case, he had that legitimate expectation that he would have the opportunity to cross-examine the chairperson of the Electoral Commission in particular. Now, let me put it right that certain misrepresentations have been made to you this afternoon. It is not true in law that a party cannot be asked to testify or a party cannot testify at the trial. That is not true. That's not a true legal position. In fact, you were all here in 2013. His Excellency the Vice President, Dr. Mahmoud Bawumia, testified during the election petition that was filed by himself, His Excellency Nana Dodangwa Akufo-Addo, and Jake Obichebi Lamte. They were all parties. Bawumia was a party and he testified. So it is entirely wrong to say that a party cannot testify at a trial. In any case, the subpoena that we are seeking to bring or to file in court is not designed to make the Electoral Commission as a corporate entity to testify or file a witness statement and be cross-examined. It is directed at Madam Jane Adukwe Mensah, the chairperson of the commission and the returning officer under the Constitution for the 2020 general elections. Now, I must put it on record that as a returning officer, she is distinct and different from the commission as a corporate body. There's a long line of decided cases on this matter, dating back to the famous English case of Solomon and Solomon. So, for them to seek to confuse Jane Mensah in her capacity as the returning officer with the Electoral Commission is, to say the least, disingenuous. And I think the lead counsel for the petitioner made that very, very clear to their lordships. And you realize that when their lordships were questioning, it was his lordship, the Chief Justice himself, who made a reference to their ruling. And in that ruling, it was that the justices took the position that you cannot compel a party to testify. And we are not seeking to compel a party to testify. We are seeking to compel Jane Mensah to testify. And her capacity as the returning officer for the elections. Okay, and she said, as I've said, it's as if to say that the chairman of the board of directors or the CEO of a company is the same as the company. You can't conflate the two. So let us, make that abundantly clear. We also want to make it clear that we are not in court seeking to compel her to testify because we think that our case hasn't been made out. First of all, let me say this. It is not left to the lawyers of the respondents to determine whether on a balance of probabilities we have been able to make out a case. They have decided that given the evidence that we have laid, they will not put their clients on the stand. It is now left to the court to decide. And by the way, the mechanism of cross-examination is a time-tested tool for eliciting evidence. Now, going by the logic that has been espoused by Kojo Opon, or the Honorable Kojo Opon Nkrumah, it means that even in a normal trial, the plaintiff will give his evidence, the defendant will give his evidence, and no one will have a right to cross-examine. And the court can go ahead and then make a decision based upon that. I think that that approach is alien to the law. It is not known to our system of jurisprudence. Let me also make it clear that there is nowhere in CI 99 that it is provided that a party cannot seek to issue a subpoena to bring a witness to testify. Now that point was made by the Honorable Kojo Opon Nkrumah, and then he tried to link it to the fact that the Honorable Marietta Brew Opon Apia Opon, was the Attorney General at the time that CI 99 was formulated and laid before Parliament. Now, if you look at CI 99, it does not provide against compelling a witness to come and testify. So the subpoena that we are seeking to issue is in pursuit of the truth. We want Ghanaians to know how 51.59589 became 50.08 something. Ghanaians, have a constitutional right to know. And so for you to say that just by reason only of the fact that we are seeking to get her to come and testify, we are doing so because a case is empty and there's no evidence to prove it, is totally disingenuous. And so for us as a team, we have made a case, but we want the court to see that the truth in this matter has been revealed. And also, you remember that lead counsel, Mr. Tachuchi Kata, made a reference to something that Jane Mensah said during her declaration. In making the declaration on the 9th of December, she said, glory to God. Okay? That she was giving glory to God for the fair and transparent elections that have been held. Now, there is no better way to glorify God than to tell the truth. The truth is very, very important. If you want to glorify God, you take an oath and you tell the truth. And Christ himself said it in the Gospel of John, chapter 8, verse 32, that you shall know the truth, and the truth will set you free. Jane Mensah should voluntarily take the box, tell the truth, and that truth shall set her free as the returning officer of these elections. May I have some questions?
Okay. Thank you very much, Dr. Ayine. The respondents have said umpteenth times that your side and your lead counsel did not show ample evidence to, as it were, ask for the reliefs he's asking for. I know as a spokesperson you say that he has adduced enough evidence, and the key word here is material effect. That's the word they used here. Are you not worried?
I didn't get the last part. Can you come closer? Sorry. Mm-hmm.
Thank you very much again. My question is that counsel for the respondent have said umpteenth times that your side has not exhibited or shown material effects to the reliefs they are asking for. And I'm saying that I know as spokesperson for the petitioner, you say that he has shown enough evidence. But on a scale of 0 to 10, how sure are you that this new application you have tabled before the court would not suffer another setback?
Well, that is an excellent question with respect to the level of certainty that it won't suffer a setback. All right? Because if what has gone before is anything to go by, I am not very optimistic. But I am disappointed that the court may not give me a reason to be very optimistic. All right. However, when it comes to whether or not we have laid sufficient evidence, the fact is this: we laid evidence to show that there were infractions, and you witness the fact that we laid evidence showing that there has been vote padding, and they themselves admitted that there had been vote padding. We laid evidence showing, for instance, that in some cases, such as in the Eastern region, they brought documents that were conflicting. We also laid evidence that stands uncontradicted, that the Form 13 that they sought to tender is an afterthought, or was an afterthought. And I think that is where they are running away from. Okay? And I will wait for the court's ruling on this one to tell you why the Form 13 is the reason Jane Mensah is running away.
Thank you very much. In your address, you spoke about the fact that the court, in this ruling concerning the application for the last one that the court sat on, ruled that indeed the court cannot compel a party to give witness statements.
That is so.
What's your operationalization of the use of the word party? Because for us as lay people, party could also mean an individual interested in a matter. Really?
Well, are you done with your question?
I am done, yes.
All right. From a legal, technical point of view, Madam Jane Mensah is not a party to this suit. The two parties, besides the petitioner, are the Electoral Commission of Ghana, a duly constituted independent corporate body under the Constitution of the Republic of Ghana. And because it is a duly constituted independent body, it could have decided that Mr. Tete or Dr. Bosman should be the ones filing this in the witness statements. Now, if that were the case, wouldn't it have been proper for the petitioner to then say, look, the person who declared the results and the person appointed under the Constitution to do so is Madam Jane Mensah, and I want to subpoena her to come and give evidence in addition to what has been given by either Mr. Tete or his fellow the deputy commissioners. That would have been proper in law under the Constitution and laws of Ghana. That would have been proper. And so to say that because she is representing the commission, she is the commission, all right, it's a legally untenable proposition.
Thank you.
I have a question. All right, thank you very much. Please, what do you say to the argument by the counsel for first and second respondent that the court has already made a determination on the fact that it cannot compel the EC chair to mount the witness box? And so you coming through with this application to reopen case and then to subpoena her is an attempt to go through the back door and essentially asking the court to rescind a decision that it has already made.
Well, I would have referred you to the answer that I gave to your colleague from the GBC. But let me explain again, okay, that the whole notion that there is a judicial bar was introduced into the argument by one of the justices. And we confronted them with their own ruling. And in that ruling, constant reference was being made to the party, a party to the proceedings. And I have just said that Madam Jane Mensah is not a party to the proceedings. Now, the fact that she had elected to give evidence on behalf of the Electoral Commission itself, on behalf of, shows that she is not the Electoral Commission. All right? Logically, you cannot say I am doing something on behalf of somebody and then turn around and say I am that person I don't see how you can do that. So for us, she's not a party to the proceedings, and therefore, all right, then if that were the case, then Roger Metilnunu is the same as His Excellency John Dramani Mahama. Will you conflate the two? Thank you.
Thank you. Yes, Amen.
Union Central for Ghana this year, we are emotion. Yabesrena Yabo, the Dr. Inikan and Notofa, a witchy casem. The Dikan will be Sasa and a Diana Yabe and or court. The Huni TV Suno, a Diana Chankasa. The Achere Titia. The petitioner, John Dramani Mahama, Wabodin crew, Ewie, Wakana Samuel. Our friend a dance for me and some media dance here amano ewie in this petition. Na nanso ehho akohia se oba court nanim na nidiem osre court ne se court no emma ne ho kwan na onsanso en reopen the case senebeya electoral commission ba no dania abato ayeto no 2027 December ono na esi ne nanso a obobo esunsunsanso no yebetumi ahye no amana bedi adanse ama John Dramani Mahama enunti de na yehu no court no eya adesrede a de abeto court na nim se nidiem omama ye kwan na yen reopen ye case na eno so te said yamote the president of the bench eya justice ani yeboa se oka no eya a settled principle of law. Say party be ebon ended na semba court no bon nkro wie frɛ na dance for wie bibi betumi asia ebetumi amana sanso aba court no was nidiem ma me kwan na men sanso reopen me case na men frɛ dance ni foforo esi da enya de foforo enu ti na justice ni yebo a e ka asem no in open court na de enti e ho akohia sɛ yeba court na nim bie na yebesrɛ court no sɛ nidiem on my kwan na yen reopen ye case and be ya ye betumi ahye Jimensa amanaba bedi adanse no ene se ye sate ya ye kasa asem no Jimensa ene electoral commission for krata o maswaide o musa sha ase a ye frɛ no affidavits ene adanse krata mpo a Jimensa na nkasa de beto court na nim no ni nyina o maka ne o mu se eye den a Jimensa beba daka mu no abedi adanse enti mu bekaya emra lawyer for the petitioner Ora Chachuchika tape se court no be ma ne kwan na at the case management stage ye bisa Jimensa nsemfo abe edumienu no Jimensa ankasa in her affidavits a chese adanse ana waswai e kan se e ma court no ma John Mahama ne na lawyer for sa kwanya no because emre be so a obeba adakam a ye betumi bisa ne sansem ni nyina enunti se edu electoral commission ne so no te se de nyina ehu ye no omo se omo asese omo adwen na omo nya mfra Jimensa biem e ma ne membe di adanse de a ene ye te se de omo ankasa etimi ka asem ba ko na no achi omo asese omo adwen court no se ye okay no the petitioner so betimi asesa na adwen se at the time when me close me case no na ye nyina ye nim se mami beba adakama bedi adanse it is ne ono se on ma media dance a anase isi say on frɛ no mani media dance ma electoral commission and you need the moment me kwan na me reopen me case na me as John Mahama the petitioner me frɛ no mani media dance ma me as an adverse witness you need the entire we was say achinya e was say twen ho dare kra because I will bet to me asesa wa adwen as the first respondent or as the chairperson of the first respondent petitioner no be subetimi asesa na adwen because the circumstances have changed na busuafo enya yenko a ena eye yenwanwa se Jimensa se say the all kase o media dance be ni nyina ye nyina ye beka no kra sem trofo aye wa ha ne Ghana for ni ye nyina ye hwe ni mu se te said there in the 2013 election petition case Dr. Farijan be di adanse be defending na juma no maame no so ebe baba be di adanse especially when nobody can wada dance and cranta mu se oba be di adanse na samu be hwa even the courts eda Electoral Commission lawyer for ka say Jimensa madaka ni mu man be dia dance bi. Mo be kaya. Even the court ka say ayo mo nwanwa. Until the president of the bench say obetu asem na hye. Na aboa ama a lawyer for na by the next day. Any of my this asem no ho komo. So enye yenko ana na ye wasa expectation this Jimensa will testify. Everyone including the bench. And if he said it was based on one kasa na numu asem na waka. Na busianfo de ye nuanom MPP for kan say Emma court no mpene so Emma yen reopen your case Emma yen hye Jimensa mani media dance Emma the petitioner because ye asem wa ye de ba court no kra no ye ntimi improve ye na te say the doctor yi ne kan ye no MPP for ko jo pon kroma onya judge enu ti se John Mahama ne na lawyer for etimi approve o masem na o mutimi improve o masem no enye ono na beka. That is an issue within the bosom of the court ye ya adwen mu de. If we say we've made a compelling case, because you have somewhere they back court, no, even the respondents have agreed to our case. That's somewhere they back court, and they say, per Jimensa Batonsun Sanswa or the two jano. We figures a woman. Oman Penya Kufuado, where 51.595 Jimensa Caso Nyano. Nemomunya 49.625. Because Jimensa Casa Numasam, the Oman Penya Kufuado Yamano. 6,713,413 and also total valid votes no and my papa ni mududu no 13,434,574. You divide 6,730,413 by 13,434,574 now multiply by 100. Obetimi ayesa calculation on your own. You get 50.098 and not 51.595. Now the Techiman South votes 128,018 votes are Jimensa ka say onyanya Techiman South results na mo be declare bano because say the same mani nyina ka joma ma ho a still candidate Akufo-Addo benya more than 50% no so we yes an kuntabuo na wo say enya no kre because the same mani ka joma ma ho a candidate Akufo-Addo ba 49.625. Declaration is so flawed say so what can even the percentages of Jimensa ankasa de ma the 12 presidential candidates ni bomu a unya 100.3%. And the Electoral Commission and the second respondents in court have all agreed that this declaration was wrong. They have all agreed. And so, to the extent, sir, that declaration where Omuamadia to Muzanya Papano, and not the only declaration to date of the 2020 presidential election. Fufrobia Mekaho, Yensisemu, na petitioner John Mahama, Abba Court on behalf of all of us as Ghanaians to defend the Constitution. So Mampenya Akufo-Addo say we are when 50% and over as dictated by the Constitution. It means that in effect they have agreed with the petitioner. Now the American to say abusuafo enya no krese Jimensa we disqualified. Now obi antumi nhye no so media dance. They said the doctor yi ne chire mu a ye lawyer penyin wo court lawyer Chachuchi Kata chire mu no. The court no kan na watwe atwa mu ne say court eni to me say obehye a party in a case na waba be dia dance party no betimi aka say me fra dance for na me fra dance for. And the party in this case is the Electoral Commission of Ghana. They be ayaba na ye fra the parties in the case ye ka the petitioner represented by ye mame Obapenyi Professor Opokunana Jane Opokunana Ajeman. Say your first respondent I say Electoral Commission. Your first second respondent is Mampenya Akufo-Addo. Jimensa onye party to this case. Onka ho bi. Obi andi wa Ghana ha obetimi aka say Electoral Commission ye obibi na nya. O the Electoral Commission court as Jimensa because the Electoral Commission is a body corporate. The law says Akra Western company law himself. A body corporate has a separate and distinct personality from an individual. And unti ye nyina ye ntia se the court no can say a party cannot be compelled to give evidence. No? It doesn't apply to Jimensa because Jimensa is not a party. Jimensa, you're on my son for. She is a public officer entrusted with the constitutional duty. Ya to abewe ono na hwe abato ono so ono na boboye esunsun so boboye no na de ne sa sha na yemra na emra ma ho kwan se utimi supina no utimi hye no e ma ne bedi andanse enu ti sa asem no mo ka no so nya no kre enu ti abusuafo ye de ya asem ye de ato court na nimni se de ye ka no na ye no kre se de ye de enuano mo ka na ye no kre no court no e de beba abonten ochena na court ne de ba ne yebetu anamon bi afa ho a yebema mahu. We are clear in our minds that we have made a compelling case. Now the air can say that bang all across the world. Now we say electoral commissioner be aye adwuma. Now your friend say omra ne yantoto na no fa say adwuma no na odwane. Why are you running away from accountability? You should even be happy, say, I am being given an opportunity to justify my role and my conduct and show, said, I am part of my penyoku. Now, brother, come near to one who miss out and Bisaka Krabi, now free, na member, na lawyer for the second respondent, and Niabra would defend it to the stand. Even the president of the bench had to come and say, Minia, as I'm waiting, I can shut down for Krasa. I don't know when you are crying more than the bereaved. So you should know, say, BBB Shewa won't pass a Ghana for Bihu. And don't let them succeed in reducing this issue to an issue between John Mahama, the petitioner, and the Electoral Commission of Mampenyo Kufuado. This issue is about all of us as Ghanaians. Yenina your constitution say, and son will be there Mampenyo, just when more than 50% of total valid votes. Or Mampenyo Kufuado enya. Nkayemu biabe to me the abacot. Bamrana say I just said John Mahama. Into what they are about for all of us. And that is why we must all be interested in this case and insist say Jimensa yen yetua ne car or some yeno. Na yedi adwuma share ne sa wo so wa ye ne yie no. Oba be bu na adwuma ho akonta yeda mu nyina ma say thank you.